that it was originally tried.
Why? There were issues with the clerk of court in that court.
The clerk of court has been convicted of misconduct and is no longer the clerk of court.
So you don't expect any other possible issues in Colton County?
Well, Colton County is not the reason that the clerk of court did what she did. That was the clerk of court's decision.
Could she face any other charges as a result of this?
We're not going to comment on any other possible. Obviously, the case against the former Colton County clerk of court was referred to another solicitor for review. That solicitor made criminal decisions regarding the totality of her conduct. She pled guilty to misconduct charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time. Yes, sir.
Did this ruling come as a surprise, and what can you tell to the people of South Carolina who might be worried about the cost of a second trial?
Well, first off, our office has always maintained, and we've never disputed, that the conduct Ms. Hill engaged in was inappropriate. We have always maintained that the conduct was harmless error. Obviously, for those of you who watched the post-trial hearings, for those of you who saw everything unfold in real time, there were many witnesses who testified that this, I think 11 of the jurors testified in open court during that post-trial hearing that they did not believe that this affected their decision. We believe that it was harmless error, and so obviously when the court came to a different conclusion, it was obviously disappointing to me personally. I know it was disappointing to Creighton. It was disappointing to other members of our team.
And as far as the cost of a second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they have a right to have their case adjudicated in court even though they're not currently here. Their family members who they left behind have a right. For those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward. Seeking justice is the role of this office. Enforcing and defending the rule of law is the job of this office. It is the job of the men and women of this office, and that is what we have always held to.
Do you plan to prosecute the case any differently this time?
As I said a moment ago, Mr. Waters and I have been in consultation all day. He's been talking with members of our team here in the State Grand Jury Prosecution Division. We don't want to comment publicly on what our legal strategy would be moving forward. Obviously, there will be very little surprises to the general public as this case gets retried again. But obviously, we have a roadmap the Supreme Court has given us based on what they have put forward in their order. But again, I don't want to talk too much openly about what our legal strategy would be because we haven't gotten there yet.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done.
We're still in that window for 3 more months. So obviously it is something that we are contemplating all of our legal options, and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on our right to appeal are things that we're going to be talking about in the hours and days to come, and we will be making those decisions. Regardless of that, it is my current intention to seek a speedy retrial of this case.
With the documentaries and the different podcasts that are already out, do you think that will taint anything in the case or the retrial?
I mean, look, you always are concerned about the exposure a high-profile case gets, and that is always something you're concerned about. But obviously the process is designed and built to kind of cull that out, and obviously I trust the process and the system to help us get back to a court of law where we can get this information back to a jury.
One more question.
How quickly do you expect you could be back to trial with this?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
You might not be Attorney General by that point.
Irrelevant. It doesn't matter who the Attorney General is. The Office of the Attorney General will still be here. Would I like to be involved in this case like I was the first time? Absolutely. But like I said, the men and women, many of the men and women who were on that original trial team are still in this office. Some have obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case is not going to be built on who the next occupant of my office is. It's going to be built on should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
I guess, Attorney General, there's been calls for reform of the system? You yourself have called for judicial reform. Given that the finger's been pointed at the clerk, are there any reforms you think should happen for clerks within the judicial system?
Look, the system worked when it came to the former clerk of Colleton County. Obviously, after the fact, unknown to us, as the court said in its order, her conduct was obviously made known. That was handled by the system. Other conduct that she engaged in, which was discovered long after the trial concluded, that ultimately led to her conviction for misconduct in office, was handled by another solicitor's office that I signed them that case, and that was handled appropriately, and she was convicted in a court of law. So the system addressed that individual.
And I know you're not going to speak about the strategy, but do you think the evidence that they pointed out that you spent too much time on the financial woes of Murdaugh, do you think that's going to have an impact on your trial going forward?
I mean, look, we have the benefit of hindsight now. We believed, and the court did say in its order that the evidence that we got in was permissible. They obviously provided us some guardrails to go back on remand to the original trial court where it will be tried, and they gave some guidelines and some guidance that we will obviously evaluate and use as a guide in presenting the next case. I'm happy, Creighton, if you want to take a moment, I'm happy to let you address that issue as well.
Yeah, I mean, absolutely. We, of course, were, aggressive about that evidence, but as you recall, we filed multiple pretrial briefs. We laid out our theory of the case. We put all that evidence on the table, and ultimately Judge Newman heard it all and agreed that it was permissible. But this is part of the process. The Supreme Court multiple times in the order said that this was viable evidence of motive, but ultimately gave us some guidance about the extent. That's how it works. You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill, and then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called superbly competent and professional presentation by both the state and the defense. So these things are not 2 + 2 = 4, and we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
Mr. Waters, thinking back to January, in which arguments were brought before the state Supreme Court, was it a difficult or untenuous position to have to, in some ways, talk about Becky Hill and basically, in some ways, make sure that, to say it no other way, to kind of defend her in that hearing?
Well, again, whenever you try a case and you, as a prosecutor, like I mentioned, with double jeopardy, you have to, within your interpretation of the rules, be aggressive. And so we were expecting that. The one thing you don't expect is to ultimately have to address these issues with the clerk. As we presented to the court, and as the AG just said, we thought that Justice Toll got it right, that ultimately there was no effect on this verdict after 6 weeks of trial and all the evidence that was presented. Supreme Court saw it differently, and that's their prerogative to do so. So certainly that was not an issue that we were hoping for and expecting, and unfortunately that was the one where the Supreme Court hung its hat. But again, that's part of the process. You dust yourself off, you get back up, you take a fresh look at it, and then you go do your job, and that's what we plan to do.
I want to close by first off just thanking the team in the Attorney General's office. Obviously, we're disappointed, but I couldn't be prouder of the job that Creighton and his team did. We lived through 6 long weeks 3 years ago, and we believe we did a good job for the people of South Carolina. We believe we represented the criminal justice system very well. A lot of people didn't think we could get a conviction, and we got it. Unfortunately, someone, unbeknownst to us, engaged in conduct that the Supreme Court believed prejudiced a defendant's right to a fair trial, and Supreme Court made the decision. While we don't agree with that decision, we respect that decision, and we're going to comply with that decision, and we're going to follow the rules given to us by the court, and we're going to move forward. Again, we will keep you all up to date as much as we possibly can on all the developments that come out. Obviously, we have a lot of work to do. We have to reevaluate, we have to review, we have to meet with people and make decisions in the coming weeks. Again, our hope is to get this case retried by the end of the year, but obviously, time will tell if we're able to do that, but that is our intention at this time. I want to thank all of you for giving us the opportunity. I'm sorry it was late in the day, but we had to absorb everything. We had to meet with a number of people, and we wanted to be able to give you this information as quickly as we possibly could. So thank you so much. I hope you have a wonderful day.
And you have been listening to a press conference held by Attorney General Alan Wilson as well as State Grand Jury Chief Attorney Creighton Waters reacting to the South Carolina Supreme Court's decision granting Alex Murdaugh a new trial. Important to note, AG Wilson saying they will seek a speedy retrial and one he hopes to be retried before the end of the calendar year.
And as we know, Alan Wilson running for governor, he was asked what if he is not Attorney General at the end of the year. His response, that is irrelevant. He says, regardless, the AG's office will be there and they will continue on with the case. We will have a live report from Columbia coming up at 6 o'clock for the latest developments on this story. You can go to our website, WIFF4.com, or download our mobile app.